Good evening, everyone. I am Akshita Bansali, student member of GNLU Center for Law and Economics, and it gives me immense pleasure to extend a warm welcome on behalf of Gujarat National Law University to all of you on the third day of the third GNLU workshop on law and economics. It gives me great pleasure to welcome Dr. Hitesh Thakkar, Assistant Professor of Economics at GNLU. He was honored with German Academic Exchange Service Scholarship for the Study and Research Exchange at the University of Cologne, Germany. He was also the co-investigator to the project titled Impact Analysis of Work Environment of Disabled Employees in Government Organization, which was funded by Government of Gujarat. Being the guiding light of the workshop, I would now like to invite the sir to address us.
So thank you, Akshita, for the generous introduction. I don't know where to start because already from last 2 days, what we are observing is like I should not say, but like Bible is spoken by itself, the God itself, like that. So who are the Law and Economics Bible? I think they are taking a session, and I think. I have to tell something what I have learned from them from last 10, 11 years. So I will try uh, s- uh, 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 whatever a small knowledge I have in the area of law and economics. I hope I am audible. Is it?
Yes, sir, you are audible.
Okay, great. So without not taking much time, I will start a presentation. So I'm planning to discuss on insolvency and bankruptcy. I don't know whether all of you have at least basic understanding of what IBC mean. Yeah, what insolvency or bankruptcy mean. If you have something, then I will very happy to know whatever the basic thing you know. So if anybody know about insolvency, I will be very happy if they can unmute and speak. Yeah, if they can put something in the chat section. Okay, so Sriram want to go ahead. Yeah, please, Sriram.
Sir, I happen to be a law professor, but my research area is on insolvency and the bankruptcy code.
Excellent.
So I think I'll be able to give you some, this thing on, what insolvency and bankruptcy code. In simple, it's just that as long as you tend to pay your debt and your obligations, you stay in control. But once there is a default, this control is supposed to transfer to the creditors. I think that's the entire, the structure of, how the insolvency and bankruptcy code has been framed, if I'm not wrong.
Great. So I think sir is telling, I think, very nicely that if you are paying a due, that means assuming if you have taken a loan and if you are paying timely interval the loans due, a principal plus interest, I think there is no question per se. But somehow, somewhere, if you have defaulted and you are not paying the principal plus interest, for us in India, it is 90 days was the given as a NPA, and after 60 days of notice, you try to resolve from your side only first. Why to go to the court? Yeah, go to the adjudicating authority, to the court, rather than you want to resolve yourself itself. So if you get money back, it is a better. But assuming if you don't get, then I think you have the legislation. Either you say insolvency, otherwise it is even called as a debt recovery legislation. For the banking point of view, for the economics point of view, either we can say even the NPA legislation, like non-performing asset recovery legislation. So focus will be on what sir was talking. I am interested on IBC, so I will focus on the dues, yeah, liquidity problem, or either you have purchased some goods and services and you have not paid, or you have not honored the amount whatever was agreed. So even the as a financial creditor, banks and financial institution, if they have given you loan, you means I'm telling a debtor, a company, a corporate, if they have got loan and they have not paid their due. So I said either a banking and financial institution, if their loans are not settled, then they consider as a financial creditor, and they can also file application in under the IBC as a CIRP process. Or even if you have given some goods and services, like you may have given goods and services to Reliance, yeah, you may have given goods and services to Kingfisher, like you have provided AC or something like real goods and services, and they have not honored, yeah, they have not honored your payment. Even you can also file application under the CIRP process under the IBC to recover your due. So what I think Siram sir has said, it is correct. Anybody want to add anything about the IBC? Anyone want to add? What do you understand by the Insolvency and Bankruptcy Code? So sorry for inconvenience. Let's start the session. Just I was telling what is your basic understanding of insolvency, and one of our colleague has clearly mentioned about the there are issues where dues are not paid. So even dues are not paid to banking system by individual, yet dues are not paid by some partnership firm, yeah, maybe LLPs. That are something a different pursuit of a different regulation that may be taken from either RDBFI Act, yeah, either it may be taken from Surface Act, it can be taken from the even the Lok Adalat can also be the mediator for recovery. So these are all considered as a personal insolvency, individual insolvency. What I am planning to take, on the issue of corporate insolvency. If companies are not paying dues, threshold of 1 lakh or above, then they can file application under IBC. So that was the initial rule. Now, if you know the post-COVID, it has been changed to the due has been increased from 1 lakh to what amount? Anybody would like to guess what was the recent change at the threshold? So correct, Raghav is saying it is a 1 crore. So even if a payment which are not paid up to 1 crore, you can file application in the current context, and previously it was the 1 lakh. So what I'm planning to do here, I will take a two paper of mine. I think they maybe have circulated the materials to you. So I will take only two papers. And last paper I will discuss briefly and just try to take your views on that. So let's go with the basic of law and economics. So this is a book which I think I have edited. In that there is a specific chapter which is about chapter 13, a deterrence effect of IBC, a forecast as CIRP based forecast based CIRP. So I'm discussing today on this chapter only. So even I got forward from Ram Singh sir and our director sir, and even they found this make us true sense of integration of law and finance and law and economics. So I'm just skipping literature review, but there are very interesting literature I found. Even I found one of our colleague has done a similar type of study on income tax appellate tribunal ITAT. Even same study a colleague has done on DDRTs also. Even the study by the on the IBC also on NCLT case past also has been done by the our colleagues on this. Even I have also studied one research on pre and post Surface Act, whether they are creating deterrence effect or not. So whether surface is stringent or not, that also study is there. But due to limited time, I will focus on the only on IBC. So if you, I hope that some of you may not have a background of IBC, but let try to understand what IBC want to do. So insolvency bankruptcy code is not to trouble company. It is specifically is based on law and economic principle, a perfect competition principle of free entry and exit. That means IBC want to rescue ventilated company. That means who is in a distress, who is in a financial liquidity problem, yeah, who is facing some tough time through resolution. So IBC provide resolution and restructuring. Well, ultimately, if we find that there is no resolution possible, then IBC also provide the exit route through liquidation. And ultimately, as per law, you can even dissolve that company. Uh, pre- our code is based on clearly, yeah, insolvency bankruptcies code is based on incentivizing creditor. That means try to see that who is creditor, who is giving the loan to you, or who has given, who is a lender. So our specific code is based on the creditor in control principle. That means it do incentivize creditor. So that means creditors are in the driving seat and they are driving the car, and it do create cost as sanction to the debtor. So it is debtor in liquidities as well as ownership shifting to the resolution professional. If your matter, if you are not paying due in present setup of 1 crore or more, then if matter is filed under the IBC, then clearly the board of directors, even CEO, MD, they are not in the driving seat. The banks, financial institutions, which are considered as a creditor, they will be in a driving seat. They, as a principal, will appoint some resolution professional. Sometimes it is also called as an insolvency professional. They will do what? So they will do take care of day-to-day affair. So what IBC do, it dictate form of resolution, design, but not form of process of leading to resolution. So do not dictate the form of resolution, but decide the process. So I was talking with some of the insolvency professional, and I was saying what is the best method or formula if I want to come out with the modeling. So what will be the suitable modeling? So he said that it is not possible that each and every company, each and every the matters have a different aspect. So what has to be followed, that is there, but specifically X, Y, Z will be a different from A, B, C to different company. So what generally happen? Creditor decide the resolution plan. Resolution plan means if company has not paid due, then we want to restructure, we want to resolve, we want to revival. And who will do that? Creditor want to decide resolution plan, and insolvency professional will run day-to-day operation of debtor as going concern from previous debtor in possession model. So now what is happening? The debtors are in the back fruit and creditor are in the front fruit. So they are the main person who are deciding the day-to-day aspect of the company. So I think though we have not discussed till now the contract, but very interesting law and economic theory is there. It is about economic analysis of contract. Can I say the credit, yeah, loan as a form of agreement? I think some bankers are also joined to us. So I think Mr. Sandeep maybe agree with me that loan is an agreement between debtor and creditor, and where it is generally understood debtor will honor the loan agreement. That means he will pay agreed time interval principal plus interest. So that is generally it's what loan uh, is being provided based on your credit worthiness, and we are assumed that you will do that. And mostly debtor honor the loan agreement and they pay timely installment at specific time interval. But there are issues where when debtor and creditor are in repeated relationship, both sides want to abide terms and condition of loan agreement, and generally it is called for the outcome as a cooperative. Yeah, it is a mutually beneficially outcome. But these are the generally 90 95 to 96% cases it will be like that. Everybody pay the interval, but there are 3-4% NPA. They are dues which are not paid to the banking system. So correctly, I think has already put in chat section Akshay that with regard to the even insurance also. So for that, I think if what Akshay is telling that credit is a contract like an insurance, contract indemnity on failure of binding loan contract, both party free to pursue legal option. Correctly. So the phenomena where unexpected breach of loan agreement or not paying dues and services may lead to non-cooperative and may not be outcome. Like that means you are not either paying the amount of loan. Yes, some has already provided you goods and services. Yes, provide you AC. Yes, provide you some basic necessity goods, and you are not paying timely, intervally, whatever the amount has been uh, delivered to you. And that threshold is more than 1 crore in present setup and previous setup of 1 lakh. I'm re-emphasizing further 1 lakh and 1 crore. Try to for understanding when IBC was enacted. If you are making default of 1 lakh, then also matter will go to IBC. In present condition, it has been changed from 1 lakh to 1 crore. So I can provide same thing in a simple diagram. If I want to say, if you see this diagram that IBC, there are who can initiate the process? Who can initiate the process that they want to recover their due? The financial creditor. So question will come, who are the financial creditor? All banking, financial institution who has provided loan, financial institution, NBFC, even they all will be considered as the financial creditors. Who can be operational creditors? So those who have provided some very important goods and services, and based on that, very important inputs also for the day-to-day purpose to the companies or corporate. Even they can also file the application. So they have provided to debtor, and what debtor is doing, either loan is been there, either supply of goods and services is there. Generally, I said honor contract will be honored. So it is not 100% NPA is there. Yeah, 100% dues are not paid. It is not like that. There is certain percentage of amount which is unpaid. Not all the amount is unpaid. So there are there are the instances where even loans are a breach, and they consider as so there are the situation where the loan amount is breach, and that is considered as a non-cooperative outcome. So now what IBC would like to do, the breach of loan agreement through IBC, through CIRP process, converting this non-cooperative outcome to the cooperative outcome. So intention of IBC, we want to make the non-cooperative give to a cooperative, yeah, beneficial to creditor and even both financial and operational creditors. I hope this is a very basic thing what we have discussed. If you have anything not understood till now, you can ask, because my mood problem, yeah, mood analysis is this slide. Till now, what I have discussed, I have assumed that you have not understood what is the insolvency and bankruptcy. So insolvency and bankruptcy can happen to anyone. It's not like corporate, it can be happen to you also. Like just you can understood that sometime we have good asset with us, like we have house or we have car or something like that, but our money is been locked in such a way that we have taken additional risk. We have invested so much amount in insurance, maybe in equity market, yeah, maybe we have additional spending over and above. Even credit card also has gone beyond that. Now, if this thing is there and some of the payment you are default, either there are some of the check, I think Ranita madam has done case on check bounce, and check bounce have a different level of legal consequences. So if that is the case, do you think that you are not in position to pay your due? Answer is clearly in present liquidity setup, you are not in position. So, but whether this is a overall bigger problem is something else is there. So something else also is there. So let me take that thing first, and then I will go to the moot question. So when you are looking at IBC, you look various trade-off. So what are that? Whether short-term liquidity problem versus long-term. Like if you see the corporate company, he has a good future in long term. He has a good wealth. Yeah, he has a good long-term capital. Only short-term, he is facing a liquidity crunch, a liquidity problem. So whether short-term liquidity problem or long-term viability problem. If short-term problem is there, I think we can restructure and we can revival and we can make that company further at the normal course. But if there is a long-term viability problems are there, I think that may not lead to the resolution. That will not lead to CIRP process, that is corporate insolvency resolution process, but it will ultimately lead to a liquidation process. So liquidation means you are selling all the asset and whatever the amount has been getting according to the law, based on the hierarchy, it will be distributed accordingly. Also, when you if you are a IP, if you are a resolution professional, first of all, when matter has come to you, you would like to see overall asset versus overall liability. So this is also very important. What is whether there is a overall assets are good and there are only certain short-term liability problems are there. If that is the case, then it will be ultimately lead to resolution. But there are significant liabilities are there. Assets are, I think, small amount. So I think there is nothing to revival. I think this will ultimately create a trouble only. So I think in that case, even you can exit and you can liquidate and sell it, and whatever the dues you can settle to the of debtor, you can do it. Very importantly, you are the management student. There are operational risk versus the market risk. Like you may have seen recently the global in COVID time, and even in the Russia-Ukraine time. So these are not the too much operational side of this, but these are too much on the context of the market-based construct. So if market-based any changes has occurred and because of that you are facing, then this is not to you, it will be to every company. But suppose if you are not in operational side properly functioning and if such thing is happening, so I think there will be different threshold for either resolution or liquidation. Already I said it is based on free entry and exit. So entry was allowed. So why not exit should be allowed like that? Very importantly, you want to revival, restructure or resolve the company, or you want to liquidate the company. Whether it is a timely solution or perpetual. If it's a perpetual, I think let it to be liquidated. Whether there is a data-centric model or creditor. Like India has adopted a creditor-centric model, which is a UK-centric. Personally, you ask me, I find what is there in US, which is a data-centric model, where even in driving seat, data will be there and there the resolution can even take place. So even that model is also good. Now, what model we have adopted and what model is been there in UK, sorry, in US, I think there is only difference is that we follow the creditor centric. So we have given a, I think, significant power to the COC, and the debtors are generally in the are in the under the control of the creditor till the resolution process is not been completed. So if I'm telling incentive versus sanction, the incentive is clearly provided to the creditor, and sanctions, I can't say exit sanction, but there are costs to the debtor if they are not paying due. And clearly there is a difference between roles in finance creditor and operational creditor. If you have given a finance, a loan, and if you are the finance creditor, you additional get voting right. But if you are providing goods and services and your dues are not settled, you are also, you will be considered at the time of liquidation, but still, yeah, at the time of CIFP process also, but still you don't have voting right. That is what law says. Only one threshold is there. If you are something 5% or more significant threshold due amount is there, then I think they may consider as a operational creditor, as a financial creditor. So this is something from the law, from the trade-off point of view. So if you have not understood till whatever I have discussed, you can ask. Otherwise, we'll go to the moot question, which is what I think. So from 5:10 to I think 6. Sorry. So within a 30-40 minutes, just I would like to focus on this aspect only. That desired aim of code is to create a deterrent effect, a high cost to prospective insolvent, so that the behavioral change involved in stakeholder in dealing insolvency and bankruptcy. So the moot intention of this research is that whether code has created the deterrent effect, whether it has created the high cost to the prospective insolvent. If yes, then that means the behavioral change are there in the stakeholder, and they have understood if they are not paying due, they have to face consequences. Yeah, they have to face problem. Yeah, they have to bear the insolvency and bankruptcy code in a very stringent manner. So this is a moot question before me. Anyone, if I see research question also drafted are like that only. Whether there is a deterrent effect, a high cost in issue related to insolvency and bankruptcy post IBC regime. What are the behavior change occurred in the post IBC regime? Whether the present IBC regime provide incentive to insolvent. If it's provide incentive, if it's provide incentive, what will happen? Do you think the CIRP proceeding will increase or it will reduce? If it's incentivizing, then it is better to settle, better to pay due. Yeah, it is okay if you don't pay due. That is also fine. So that is what I think the question is there. So for your information, what we have seen in the simple game theory, I am taking in a repeated game theory. Now, what is repeated game theory? It's a very simple thing, uh, we have a friendship relationship with one to or other. Akshay sir is a good friend of Pratik, and even the friendships are tested on difficult time. So at the difficult time, Akshay sir was expecting something from Pratik, and I think Pratik has betrayed. Yeah, Pratik has not provided cooperation during that difficult time. So that is a one instance. Now there is a second instance also, that even in second instance also you find the same thing. Even in third instance also you find the same thing. What you understood in the repeated game theory? Can you believe that Akshayji will trust Pratik in long term? Let's take one other example. Like we are taking a match between India and Australia. So India has win first match. India has win second match. India has win third match. India has win fourth match. And India maybe assume lost in fifth match. What do you consider in the repeated game theory? Can I say Indian team is stronger and that's why they are winning the cup? Can we say yes or no? Maybe one instance may be random, but in all other instance it was the correct thing. So what if same situation occur further and further in, that is called the repeated game theory. I think when mm, Ulan sir will take prisoner dilemma, I think you will be very appreciating the repeated game theory. So what is if CIRP process either initiated by operational financial creditor, yeah, either it is initiated by the operational creditor. If I am assuming it is a high cost to the defaulter or prospective insolvent, that means there is a high cost to the debtor if the default take place. What will be that? Don't you think that will be a deterrence? And even what the insolvency matters which are going on, what they will tell to the even other colleagues, yeah, other companies or corporate, that brother, first pay the due. If you're not paying the due unnecessary, you have to face the musics. Uh, Yeah, Sriram sir, I will take your question in just completing this aspect. So that is the initial round. That means everybody has got message clearly that if you are not paying due, then unnecessary you have to bear a significant cost. And if that is the case, then the message has reached to the all the stakeholders, corporate companies, and their behavioral changes are in the process that yeah, we has to see this law very stringently. And suppose this incident happen in first round, but suppose in repeated also round due to high cost of default, don't you think that matter of insolvency will increase and matter of insolvency will reduce? Whether you would like to pay due on time or whether you would like to go to court. If you are not paying, you have to bear consequences from IBC. So what you wish to do? What is better for you? To paying due or not paying due? And if that is the case, do you think more matter will come to the CIRP process or less matter will be there? Can I say less matter will be there? Yes, no?
Yes, sir.
Yeah. So if that is the case, and even if matter is going to the highest court like Supreme Court, and there also I think true sense and intent of legislation they are making. So they are not even diverting, they are not making a wider perspective, broader perspective. They are putting in a only intent, and that is the efficient base, timely recovery. A fair value has been there, timely recovery is there. They are just going with that sense. If that is the case, tell me what will happen. Number of default will increase or number of default will reduce? Number of default will reduce. So I think Sriram sir was interested to ask something. So if he can unmute and ask his question.
Also, I just wanted to answer, nothing else.
Yeah, please, sir.
No, no,
Sir,
I
what
just
you
wanted to answer, nothing else.
can you answer what you wish to answer? I just sorry I could not that
No,
time.
you were asking about the number of insolvency cases, whether it would increase or decrease.
Okay.
I was like, let me just answer the query.
Okay. Okay. Great. I think you are with me only. Thank you. So somebody is telling, what do you mean by cooperative outcome? Yeah. So cooperative means it is not going against to both of us. I think it is better for both of us. Non-cooperative, if you are paying timely intervally, what is the problem? I think it's a great thing what is happening to both the party. So this is a one aspect. So whether it is a high cost or whether it is a low cost. So there is a certain second theoretical construct I am telling whether in repeated game theory, IBC is low cost matter and low cost to the defaulter or prospective insolvent. That means in IBC case can be delayed, can be diluted, can be made more complex. The recovery will be not fair. Your recovery value may not be there. It may be taken additional time. Even value of money is also not there. What is there? So suppose if it is low cost and anybody is initiating CIRP, either financial creditor or operational creditor, if low cost to debtor if default take, don't you think it will incentivize defaulter? If yes, and that is the initial round, what he will tell to the prospective colleagues? Yeah, what will tell to the all the corporate companies or all other stakeholders who are related to him? अरे कोई नहीं चलता है मतलब you pay not pay nothing matter. I think IBC is like it's like you can play with that system, and I think it's nothing to worry about timely settling or paying the due. If that is the case, what will happen in the repeated game theory? Due to low cost, if no change in behavior pattern occur, don't you think there will be more number of cases and more number of default will take place? Yes, no?
Yes, sir.
And if that is the case, what will happen in the if matter is going to the highest court, like Supreme Court and High Court, where even Supreme Court is taking a wider or broader interpretation. It's not going with the true sense of intent of legislation, where the fair value, the efficient value, and timely recovery was the main concern. It's going with the different aspect, and it is going with very broaderly, widerly, and which is diluting even and delaying the process. If that is the case, what will happen? The number of default will remain same and number of default will increase. Surely it will increase. So question here, same thing. Insolvency law aims to create deterrent to the debtor and empower to the creditor. So question same I am asking, what do you think? Whether IBC is high cost or low cost. So what is your guess? You can just put in chat section and we will see whatever your guess are, whether correct or not. I will show you through data analysis whether it is a high cost or low cost. Anybody still who have not understood what is the high cost and still you have not understood low cost, we can discuss. So Gitanjali madam is telling a low cost, even Siram sir is telling a high cost, Sita ideally telling the high cost, okay. So I think some of them have taken a stance, some of them it is believing that it may be both. So they are, okay, many of them have taken a stand, great, I think, yeah, good. Okay, somebody has doubt regarding high cost and low cost. If you can unmute and ask, I think that will be great, Milan. Like if you're not paying due and you will be taken in a different context, and if you are and that is even it is creating differently to the your company brand and that. It is better to pay due, yeah, it is better to dilute that. High cost means if you are not paying, I think the stringent procedure will take place and it will be go according to what law has been prescribed. Low cost, even law provide everything, but even you can dilute everything and anything. If that is the case, then whether prospective insolvent will be in a better off if they have low cost because they can dilute anything and everything. But if that is a high cost, then they don't know what may happen to them. So many of you have taken a stand, so let we can go further and let's try to see because we don't have much time. Let's tell you one more interesting thing. Like generally, what is the input for the such matter? So input will be always default, yeah, liquidity problem, either by companies, even it can be LLP, partnership, individual. So even you can make same analysis for DRT, DRAT, something like that also. But I'm discussing more about the company. So what will be the output? Output will be resolution or revival that finally you want that company can restart with some new financial the changes, their restructuring. And there is no possible of revival or restructuring. If we think that that company can't survive, then output second will be no resolution possible, then it will lead to liquidation. So this too can be output. If you are looking IBC, insolvency, bankruptcy as an industry and enterprise. So this is the process how IBC take place. I don't know whether you know about the how process take place. You want, then I can discuss. Otherwise, I can move forward to the analysis. Anybody who don't know how process take place, so we can even discuss how it's work. Otherwise, we can skip this slide and we can go to the our research finding. So should I discuss how it take place? Some of you who are not knowing how the insolvency proceedings are taken. No response. Okay. So first and foremost, default has taken. So let's take the Kingfisher has defaulted. And you know about Kingfisher has already defaulted to the SBI. So SBI has filed the application to NCLT. Generally, under NCLT application is been filed, and generally there is a prescribed format is there. It is a now online system. So whatever the prescribed format is there, you have to fill everything. You don't have to miss any information. Like you know that when you are applying for any vacancy, there is one clause. If you have missed out something, if you have wrongly fulfilled something you have done, then I think you are taking a different level of risk. So here also it is like that. You will take care of all the liabilities. So I think you are not doing. I think we have some expert here who are even dealing with IBC case. I think we'll ask them to do so that you don't have to at least worry about the filing application of that. So if you have done completely application, then it will be admitted in a 14 days. So we'll discuss further, sir, about how the game theory work in the committee of credit in the later stage. So it is admitted in at least in 14 days. So 14 days till 1 to 14 days time is there. And when after admission, you first and foremost it happens that we declare the moratorium. So moratorium for law, I don't know what may be, but for the economics, it is a very interesting thing. You provide a silence. You provide everything gets stopped. Any other matter, even of Kingfisher, maybe other complex matter which are going in High Court, Supreme Court, anywhere, anything, let that be remain as a break for one time. Let give the CIRP process to take place and let come out with the resolution process. So you declare the moratorium where even some of the pending case also get the break. So what you do here, you appoint IRP. IRP is nothing but interim resolution professional. Word interim is that because it is initially appointed, that's why they are told as interim. And first, when you appoint somebody as a resolution professional, a insolvency professional, first and foremost job what he will do? He will do public announcement. Public announcement, SBI dues are not paid by Kingfisher. Then you find that even Sriram sir, Asita, Akshay, they all, even Sandeep, and many other them, they find that even the Kingfisher has defaulted to them. So even you can also put forth your matter that such you are unpaid. So even you are publicly announcing, that means even we want that even any other people whose amount has been not paid yet, you are not settled, let that also come. And after public announcement, first and foremost, we will constitute the COC. COC is nothing but the committee of creditors. So who are the committee of creditors? The financial creditors are the part of the committee of creditors. So all the banking financial institutions whose dues are not paid, they are the part of the committee of creditors. Like suppose take example of 1,000 crore has been defaulted. 500 crores is of SBI, 400 crore is of HDFC, and 10 crore is of F, maybe Canara Bank. So if total 1,000 is that, can we say that 50% voting right is in COCs with SBI, 40% voting right is with HDFC, and 10% with the Canara Bank? Yes, no. So when you are constituting COC, you take care of the financial creditor, and total COC has been constituted. And first meeting in COC, what you will do, either you will appoint same IRP as a RP, same resolution professional as a interim resolution professor, insolvency professional. Either you can go with something else. You can appoint somebody else also in place of that. If you find it's not good, it's not efficient, even you can do that at the later stage. Maybe SBA may be initiated, but SBA may not be big player. Maybe later on other big player may happen. So in COC, even you can decide somebody else also. Now, first and foremost, after resolution professional, insolvency professional is appointed, his task is to come out with the information memorandum. So, Janam Kunli, you have to provide of that corporate, a company, what is their overall asset, what is their overall liabilities. So, if you provide that, so post after information memorandum providing all minute to minute and every all required detail with regard to finance, you are ready for inviting EOI. EOI is expression of interest for resolution applicant. So what resolution plan you are suggesting? So it can even invite it from the operational creditors also, and ultimately, and the best suitable plan will be IP will place before the RP will place before the COC committee of creditor, and based on present is 66% voting right. Earlier it was 75, but now it is reduced to 66. Based on 66% voting right, you can put forth approval from AA. So you will put forth NCLT for the approval, and generally NCLT approve if you have followed the financial wisdom and that. So this is the way the process take place. So let's move toward the main interesting thing which I was interested to tell. If you have understood whether it is a high cost or low cost, then what I have done nothing big thing. I have just taken the time series forecasting where the data were there from 2016 till 2019 quarter 3. So based on this data, we are forecasting 2019 quarter 4 to 2020. So we are forecasting 5 quarter 19, 20, quarter 1, 2, 3, 4. So what forecasting means, if you have a previous year data, you can clearly say what will be the what may happen in future in that way. Like if suppose in GNLU we have BA data, BA students data, BCom data, BSc data, and if we take last 10 years data, then we can forecast that how many number of students intake will be there in BA, BCom, BSc. It may be coming near to that if the trend and patterns are following based on the historical movement. So clearly, if you see this table, the red line, what you are seeing upward, it is actual data, and model, the blue line, what you are seeing, it is a model line. And model line is predicting that number of default, the number of cases will increase in quarter 2019 to quarter 2020. So there will be more number of CIRP proceeding will take place in the future. That's what the forecasting analysis want to suggest. Even similarly, if you see, red line is the observed data and blue line is the model line, and even based on this you are forecasting that even in future there will be more number of liquidation will take place. So first insolvency matter will increase, and in insolvency which are coming, even that in that also there will be significant liquidation is taking place. Now with regard to who are the service provider, who are taking care, who are the taking infrastructure part, they are the IPs, they are the resolution professional, insolvency professional. So the red line is a very scatterly and it is seasonal, it is up and down is there, and where model is forecasting that there will be a constant IP will be registered. So that new IP which are coming, they will be remaining in constant, and who provide license to IP, they are called IPA, Insolvency Professional Agency. You know that CA agency, ICAI, that is also the agency. It is one of the CACS who is providing license to them. Even they are same providing license to even IPA and RPA. They are also remaining constant. If that is the case, can I conclude that the CIRP and liquidation at the beginning stage, at the end of quarter, show positive trend? That there will be more number of cases will be there for CIRP and liquidation. If that is the case, do you think it will be taken care by same insolvency professional? Yeah, it will be the same insolvency professional has to take more number of cases. If cases are increasing, both of CIRP resolution is also increasing, and similarly companies also liquidating. If that is the case, what will happen to the given IP? Do you think same IP we has to deal with more cases or not? If that is the case, don't you think that the same IP is dealing more number of cases? Don't you think you will be overburdened? Generally, when you are asking IP, insolvency professional or resolution professional, to even think about to taking operational part, I don't want to question the authenticity of IPRP. They are good in financial thing, but now we are even asking them to do day-to-day affairs. So you are asking even them to take the operational thing, and in that also we are overburdening them. Then what will happen? Uh, don't you think it may be somehow somewhere maybe get inefficient result? That's what can we say. So what I have concluded that if there is a behavioral change in group of insolvent, but data still predict that there will be more number of CIRP and liquidation are taking place. So whether clear message of IBC stringency has reached or not, that is a question. And I feel that IBC IP are demanded more than supply. So there is a possibility of shortage of IP. That's what I'm concluding. If you have any question till now, you can ask. If not, then we'll move it to the something post what additional other research I wish to discuss with you. So can I say this is a high cost or low cost? If number of cases are increasing, number of defaults are increasing, should I say high cost? Yeah, it is a low cost. It is a low cost. If high cost was there to the prospective default, I think they maybe have paid their due. And even number of people who are not paying due, they may not try to wait till matter is been reaching to the CIRP process. So even application is been filed till you have 14 days to admitting the application. So it will be better to pay the due rather than allowing matter go ahead. If you're allowing, that means somehow somewhere you have misunderstood IBC and you are considering this as a low cost and you feel there will be no consequences to you. Yeah, please, Sriram sir.
But it still is high cost, even though there is a rise in number of cases.
Okay, how it is a high cost?
Because the promoters lose their control, and
Hmm.
secondly, if it's a listed entity, you lose your stock market price. So these are all
Okay.
no unrelated costs, but I think it would still constitute as a high cost because basically India is predominantly a promoter held jurisdiction,
Hmm.
so they don't want to lose their control.
Hmm. So what you are telling is correct, but the results are not telling that, sir. Data is telling something else to you, and still you are considering they have they feel that this is low cost. That's why they are behaving like that.
True, sir, true. But we are also a little irrational jurisdiction that sometimes even the results might be, little erratic to this way. I don't know. I'm just,
No, no.
suggesting.
What you are saying is the next point I'm trying to say. Now I am taking a different stand. What you have taken. So this paper was telling something, and next paper I think which I will take in 20 minutes, where I will discuss what you are saying. I'm just going to that. Still, anybody who have not understood the previous discussion, because that is it is in the synchronized with that only discussion. So if you have not understood, you can ask. Otherwise, what you have said, I'm just going to that point. So generally, you know that movies are coming, KGF.
Dr. Thakkar, one question. So
Yeah, madam.
is the IBC itself low cost, or does it get diluted, and become low cost in the process?
So what you are saying, I think I will be appropriate if I tell you the complete truth. I have given the partial truth only. So Kattappa ko Bahubali ne kisne mara tha, it will be just known through part two only. So if it's
Okay.
fine if I discuss, and if that's still not answered, we can re-discuss that.
Okay.
So let's go to KGF 2, yeah, Bahubali 2. So I think here I think the skills of Ram Singh sirs may come. So this is a one paper on settlement and that. Even he has not discussed anything. I am interpreting. I may be wrong also. Later on, you can tell me. There are nothing he has discussed, something like that. I am interpreting that. Hopefully, it is correct or not. We'll see at the end of the session. Now, I'm adding one other variable about the settlement. Yeah, out of court settlement. Now, some of you who are knowing about the law, yeah, who have read the IBC, they may be knowing there is nothing mentioned in IBC about the out of court settlement. That I agree with those who have read the legislation. But try to understand there is very important uh, uh, thing is mentioned, which is called withdrawal of cases. So you can withdraw even before the application is admitted, even you can withdraw before COC is constituted, even you can withdraw before EOI is been invited for the resolution. So these are the three stages where you can withdraw. So IBC looking with settlement, yeah, with looking with the settlement, yeah, out of court settlement, yeah, with withdrawal, whether it is a high cost or low cost, that is what I think we want to see. And I think what Sriram sir was telling, I think something has to be relook like what I may be slightly giving a ironary conclusion. Yeah, what Ranita madam was also telling that it may be because of some other thing. So let's see actual truth and then try to dissect. Yeah, then try to conclude something. So this is the paper I will request all of you to read, but there is nothing discussion what I am making, but you can get this discussion through what I'm trying to say. So I'm just skipping this slide because this was only the introductory slide. I think this what already we have discussed. So same moot question, whether desired aim of code is to create deterrent, a high cost to the prospective insolvent, so that the behavioral change to involve stakeholder in dealing with the insolvency and bankruptcy. So that is what the moot question. So same, we are taking the high cost. If it is high cost, you can understood that deterrence will be there, number of default will be I'm adding one thing, whether high cost is there, then it is better to have a out of court settlement. If true sense of intent of legislation take place, then also it is better to do out of court settlement or withdrawal. So this thing, what it is been discussed, I think it will better if I just try to explain in the later part, then we'll re-come to this discussion. So I'm just keeping how the process takes place. I think everybody know default has occurred and we are coming out with the resolution. If resolution is there, we are asking the authority NCLT to approve. There is no confusion. Now you will get clarity here. So what is input? Input is a default. What is the output? Output will be resolution. What is the output? Output will be a liquidation. If resolution is possible, if you can revive that company, if Kingfisher can revival possible is there, then you will allow for resolution. If it's not possible, then it will lead to liquidation. You will sell all the assets and whatever the amount has been recovered, it will be paid to the creditor. And this way, whatever the hierarchy has been provided, accordingly it can be done. I think I was missing the real truth here. There is third other phenomena is there output that is called out of court settlement. Yeah, settlement. So there is a third other possible output, which is a settlement. So I have not given any scope of settlement in that first paper. Now there is a clarity that settlement also can take place. So let me tell you something law behind the settlement. So there is one specific rule 8 is there, which says that even application is admitted before the admission of application. I was saying default and you make a form and 14 days. So before it is admitted, even you can withdraw that. So that is rule 8. Rule 11, at any stage where the committee of creditor is not, COC is not constituted, even you can withdraw. That is rule 8. So I'm skipping this stage 1, stage 2. That is a different level of understanding, but I'm just keeping only the different effect part. The application end can be withdrawn after constitution of COC, but the issue of EOI. So these are the three rules which provide that even whatever the application you have filed, it will be withdrawn. Tell me the withdrawal will happen in isolation? बैंक अपने आप ही विड्रॉल कर देगा कि सामने वाला डेटर आके बैंक को हाथ जोड़ता है, भाई साहब आप जो पैसा मांग रहे थे आप ले लीजिए, वट एवर योर मनी ड्यू इज नॉट बीन पेड, आई वुड लाइक टू पे यू एंड प्लीज टेक आउट एंड प्लीज विड्रॉल इट. It will happen like that. It will be happen only wins and flimsy of one sided of the game. It will be happen with the consensus between debtor and creditor. So generally it will be happen when you are trying to uh, uh, partially or completely settling something, like then and then only somebody would like to withdraw. So let's try to see in even the that when withdrawn can take place. If application is admitted in 14 days, even you can withdraw that. Even you can withdraw before COC is constituted. Even after COC till EOI has been invited, even you can withdraw on that. If you tell me and if you ask me, I have talked to many IP, even they say post EOI also many withdrawn has happened, but law doesn't allow. But he was saying that even the withdrawal can even take place there, even the settlement even can take place. But if you go with true sense of law, then withdraw before EOI, before you are inviting some resolution application, there the withdrawal can take place. So this is the data I want to show, and just I want if you can forecast, if you can just try to focus here. Try to see that 16,473 cases. That means 82% of the cases were withdrawn in Rule 8. Even matter was not admitted before that 16,473 cases were withdrawn. 2% cases are withdrawn in the section 12A. That means post COI has been constituted and post the EOI has not been invited. So you can see 84% of cases are withdrawn. 11% are being determined through CIRP process and 5% has gone for the liquidation. This is the data we are having. Now just try to see, tell me and try to understand any withdrawal, any settlement will happen with either 100% settlement or partial, that may be 50% and more settlement. Can I say that? Even 75% also. Whether this settlement will happen with haircut, bank may would like to, financial institution may would like to make a loss of 20, 25, but not more. Can I say these settlements which are happening, which are generally near to the full settlement, if I average out, it will be like that only. Yes or no? Any settlement which are happening, do you think it will be settled with what is I want to say that suppose SBI has to recover 100 crore, whether SBI will getting Kingfisher is ready to settle, whether SBI will accept anything less than 75 crore if they are doing settlement. Generally, settlement will happen only and only when they are getting either full or more than 75. Something more than 75 that is happening, then and then only they will like to settle either 100 or around 75 to 100. If that is the case, what I am saying, generally settlements occur when near to full settlements are there. And in what logic I am telling, I am just providing data to you. There are full settlement of 34% of cases with the applicant. Full case settlement of other creditor is 7. So around 41% are this. Agreement in future, so around 47 with other creditors. So if you add this, it is coming around 73 to 75% of settlement which are happening. So what I wish to suggest that mostly, and in this 28 others, so they have not specified even in that 2-3% recovery will be there. So around 75% recovery will be there. It will be not less than that. Now this is one fact before you. Now what is second fact? If CIRP process, a resolution process is deciding the recovery, then it is a 43. That means what will happen? Kingfisher will only pay 43 crore if 100 crore due is there. If 1000 crore is there, then it will pay 430. If 100 rupee, if 100 rupees, then they will pay only 43. So if resolution CIRP process, resolution process is being decided in that recovery rate is 43%. And if there is no resolution process agreed, then it will lead to liquidation that only 7%. If Kingfisher is going in liquidation, then in 100 crore you will get 7 rupees. Even you will get here 70 rupees, not more than 7 crore, and you will get a 70 crore like that. So what I would like to tell here that in this, at least 75 in this, if you look at, if out of court settlement happen, then it will be 75% or more recovery will be there. If CIRP process is happening, then recovery will be 43%. If liquidation is happening, recovery will be 7%. That means, so if 100 rupees there, then 75 rupee will recover through settlement. 43 rupee will be recovered through resolution process, and 7 rupee will be recovered through liquidation. So in otherwise also, don't you think that settlement is an efficient way for recovering due? So I think it loudly it is a best way to do. Now, now I'm coming to the high cost argument. Do you think this settlement will happen without IBC? Think and tell. This is a very important question. Do you think if IBC is not there, still debtor will like to settle? Is it so? Tell me when settlement started, when you have filed the application. जब बात पता लग गई कि the matter has come to the NCLT and it is found that you have defaulted and they are planning to take the consequences or cognizance based on the application what has been filed against you. You are trying to settle. Tell me if there is no IBC whether this settlement will take place. Answer is clearly no. So try to understand one first more important thing. IBC is there. And because of IBC, the stakeholder, prospective insolvent, are knowing if they are not paying due and they are not settling due, they has to bear the consequences. And they are settling. If dues are settling in such significant amount, 84%. What the significant percentage? Don't you think that IBC, what Sriram sir was telling, it is not low cost. It is a clearly, truly a high cost thing. Further, I want to re-emphasize one thing. When you are looking IBC and when you are looking settlement, settlements are happening because there is a IBC. And because of IBC, people know that if they are not settling, then they have to bear the consequences and they are settling. See the number of data, number of cases are getting settled. Significant number of cases have been settled, around more than 16,700 around cases are has been settled. Threshold number which have been settled. Why such significant percentage threshold will be there of settling? Because they know they have to bear significant cost, and that cost is really significantly high. So as what Siddham sir was telling that they will be not in driving seat, the board will not have day-to-day decision taking, RP will do everything. And I think they are under the slavery of, I should not word use slavery, but they are under the control of committee of creditors, and they are unnecessarily accountable to resolution professional and that. So don't you think that when you see IBC with the settlement, it, in true sense, it is the high cost matter, not the low cost. If you have understood this thing, then I will take something else. Otherwise, no. If you have any question till now, you can ask because I think we have discussed uh, the part two. I think complete. Still, it is not complete. I may require something more time, but still, if you have any question till now, whatever we have discussed, I will be happy to answer. And lastly, I will introduce part three in 2-3 minutes, and I will close uh, uh, my lecture. Any question? Any observation? Any comment? Can we
Sir,
yeah,
the forecast that shows increasing
Hmm.
insolvency cases, that part does not factor in the out of court settlement, no?
yes, madam. It has not factored in.
Okay.
So this out of court settlements, even data are very hard to get. It is not even put it in the IBC also. So you have to collect this data from various other sources and then you can tell. So in rule 8 for getting how settlements are happening, it was difficult. Otherwise, these data are available. This 2% section 12A, I think that data is available. How to get that is available in IBC, but this 82% that stage 1 data are not available. So for fetching that data was a very hard task. So if there are no questions, should I go further? Because I think I have skipped the other argument also. But I think,
Vijay here, shall I?
yeah, go ahead, Vijay.
So, if I correctly understood, the data is from 2019 to 2020, quarter 4 to quarter 4.
That previous data was like that. In this out of court settlement, it is till 2000. You can see September 2020.
Okay, so my concern is in this case, what is the coverage of the data? How up to what timeline you followed to reach to this conclusion that settlement plays better, much better role than the rest of the things.
So clearly, I don't think it has required to think in a bigger way because this chart shows in a very clearly way that people are settling. A significant number of people are settling. Even debtors who are the company corporate are better to settle rather than they want to face the consequences of IBC. Why they are settling? Tell me. When you will settle? Either you can allow the
That's
matter
my
to go ahead with this CIRP. You are settling, so many people are settling. That's clearly so that somehow they has to bear a different level of significant of consequences. So that's why they are settling that due. And the number is clearly higher. It's not a small amount. So I think you can clearly tell that this settlement uh, provide the high cost that those who are involved, stakeholder, the debtor, the company, corporate, who are earlier taking very lightly IBC, I think they are not taking lightly because they know that if they are not paying due, I think unnecessary that will deteriorate their brand image. What I think Sriram sir was telling, even the stock, other many things, even I think your overall control is being taken from you. I think you are just like I don't want to say you are the person, but you don't have any power, and your company is being controlled by the banking and financial institution who are the committee of creditor and resolution professional, is taking day to day operational tasks from you. So how you will feel like? So it's clearly that this, if you like what Anita madam was telling is correct. You factor in the settlement. I think then you get the complete picture that IBC is really truly the high cost, not the low cost. I don't know. I have answered your question. Yeah, I think then.
Partially, sir, my point was like this data, like source of the data, which you have taken, this number of companies, like 16,000 companies plus 291,
So it is there in
2000.
IBC reports are there. It's not like directly data can be fetched. You have to read all the reports. If you read all the reports, you will get this data.
Okay, thank you, sir.
I think he's asking about the timeline, isn't it? What
So
is
it is up to 2020 only, September 2020. But यहाँ पे I think one thing I'm not just already Thomas sir has come, so let me stop here only and let Ulan sir should start. But just I will take one more thing, which is a part three. If Professor Ulan is fine, can I take 2 minutes, Ulan sir? Yeah, great. Still, I have not told everything. There is many other thing. Sorry, I have not completed full paper, but I want to go with I think the part three. That so that you read this paper. So you know that TGF 3 is also coming, and Jurassic Park 5 or 6 is also coming. So Insolvency Economic Analysis 3 is already there. I think you must have to read this paper, which name is Pre-Package Integration or Data-Centric Model with versus the Creditor in Control Model, Indian Insolvency Regime. So in the earlier discussion, I have not discussed that the threshold limit was increased from 1 lakh to 1 crore. If default is of there of 1 lakh earlier, then you can file application under the IBC. Now it has been increased to 1 crore. So what about the default which are less than 1 crore? So there was nothing there. So what happened in India? We enacted the pre-package system for MSME, and where threshold is a 10 lakh and above. So 1 million and above. So the question, just I will take one part and then I think I will close in 1 minute. So let's take one interesting thing, like suppose Sriram sir is having a very interesting enterprise, MSME, is having a own form of micro, small, medium enterprise. And suppose Mr. X has defaulted him and the default is worth of 7 lakh. Do Sriram sir can file application under pre-package? Answer is clearly no. If default is of 9 lakh, then he can file a answer is clearly no. If default is of 10 lakh, yeah, 1 million, then and then only. I have problem in that. Like suppose this X has defaulted 7 lakh rupees. And when this information is reached to other player also, it has not defaulted to Sriram sir also, but it has also defaulted to Vijay also. So Vijay around 4 lakh default is there. Don't you think cumulatively it is going 10 lakh and above? Do you think Vijay is staying in Gujarat and I don't know, Sriram sir is supposed staying in some other part? They don't know that X has defaulted to both of them. Don't you think both don't know who? They know X, but they don't know both of them. And law provide that if default is 10 lakh and above, then and then only you can proceed for the pre-package. So what will happen in that? So what personally I feel that the law should be made in a such a way that it should be allowed a threshold of 1 lakh for initiating. But matter will be taken ultimately if the cumulative default is 10 lakh. There may be the X may be a default to maybe many other people also, and is defaulting to 2, 5, 5, 6, 6, 7, 7 lakh, but they all are less than 10 lakh, and they all of them are not knowing the default of overall cumulative default of that it is going even beyond than the 10 lakh and above. So I think this can be thing which is missing in the present law. But otherwise, the pre-package provide the solution where from beginning only you have a base resolution plan. So you have resolution plan from beginning. And clearly what I think Sriram sir was also telling that in this, it is a hybrid model like US centric where even debtors are in the driving seat. So debtor will propose some base resolution plan. Now, possibility may be that when they are proposing some base resolution plan, they may be having a nexus with the financial institution and banking system. So it is better what they are proposing. Let check some alternative plan. Let take out some alternative plan from the market. So that is what pre-package. So you're from beginning only you are providing the resolution plan, and then you are asking from the open market that if any other base resolution plan is there and it can offer better than what the base resolution plan is offered by the debtor, I think we can check both the plan, yeah, alternative additional plan, and then let give the complete the process. So pre-package is it is initiated only for MSME in India. I feel why not it was even initiated for the CIRP process. And there is something very interesting discussion is there about it. So I will not take any further discussion on this, but please read this article. And if you have any comment and anything, it's uh, surely welcome.
Shriram sir was asking something. Please ask.
But with regards to this pre-packaged thing, I think my observation would be that the government actually wants only the financial creditors to take part in the process, because the CERSAI registry would actually show how much of the amount is actually due amongst all the banks, and they can act in a coordinated manner. In fact, this is an extension of SURFACE Act. What would you say?
Like because surface is per se specifically of the collateral debt base, and if anything is based on collateral, why do you want to take it pre-package? You have full freedom, sell it to the open market
Correct,
and
sir.
whatever.
But the trickling down effect of the deterrence effect, the deterrence effect of SURFACE started to gradually lower down. Then they brought IBC, and then they
So
bring up pre-packaged, in which again the banks are the participants.
So if you are telling the surface is not having a deterrent effect, then I will share you one paper of mine which do discuss about that, and it will be very interesting to see. I even said that surface is not stringent enough, and I have provided through data analysis same thing, and I agree with your at least point with regard to surface is saying in isolation for the personal insolvency, even that also do have some efficacy problem. But I think let's if any other has any observation comment, I'm happy to take. Otherwise, we can I think start with the full answer session.